Okay, we're gonna get started with AB 1490. This is a bill that provides for adaptive reuse. It's mostly intended for hotels and motels, converting them to residential use. Basically 1490 provides that where there is retrofitting and repurposing of a residential commercial building to permanent housing, and that meets certain requirements, such as it's on an infill site and not adjoining to an industrial use, that dedicates all of the housing to lower income households, including 50% to very low income households, then a jurisdiction has to approve this type of project through a streamlining process, basically within 60 days for projects that have 150 units or less than 150 units, and 90 days for projects with 150 units or more. And you can, the jurisdiction can impose objective design review standards, subject to some exemptions, but can only deny the project if it adjoins an industrial site and they make a finding that it would have an adverse effect on public health and safety. So that was pretty straightforward. Any questions on this one before we move on? It's loading. I don't know that.
I don't know. You have the spinning wheel of death. I don't know. Does it work if you?
I'm afraid it's not helping.
What's that? They didn't say that.
Excuse me, sorry, I came late. Did this one already pass this?
Yes, so these, we're only covering bills that
Okay.
have been signed by the governor and that will go into effect next year.
So it's good.
Most of them in January.
Next 2024, January?
Yes, January 2024.
That sounds so much like a project that I'm familiar with.
PowerPoint A.
Converting a hotel room to the residential.
No, it was
That's exactly what it is.
residential.
What was it called?
So we take a look.
I also have,
It's got two monitors as extensions.
Office.
I also have on a flash drive and a laptop implemented.
They're having trouble with the pipe.
Can I ask you a question?
Sure.
Or waiting, so when you say, would be subject to design review standards, what is
That's my guess.
That's
I've got over 9 years.
that the same?
So that's actually one of the exempted categories.
Restaurant.
So it says the jurisdiction cannot impose or require curing of any pre-existing deficit or conflict of maximum density requirements, maximum floor area ratio requirements, parking, and open space requirements. So otherwise, any other objective standards, setbacks, things like that, they can require those to be cured. But you can't deny the project on the basis that they don't meet those requirements.
I think the internet's slow. I think that's what it is.
Oh, I have it on a drive, if that would be easier.
But it's connected to Zoom here.
Oh.
Can you shut the clicker, see that works?
It's not working.
Construction.
Okay.
I'm gonna sell it for 4 years.
Hopefully we don't have to do this with every slide.
What's that?
I mean, now, I want to do a lot of landlords.
Okay. So I'll provide a little bit of background on what SB 35 is, since folks mentioned that they not worked with it previously. So to start at the very beginning, the state has what is called the regional housing
Regional housing needs allocation.
Needs is always the word I forget. The regional housing needs allocation, which is the state mandated amounts of housing per cycle, which is typically an 8-year cycle that each city or county needs to build. Those are broken down by income categories. So they say you need to build X number of units at above moderate income, X number of units at lower income, X number of units at very low income, so on and so forth. And as I mentioned, those are allocated on 8-year cycles. People might have heard of housing elements that cities and counties prepare to say how they're going to meet their RHNA throughout that planning period. And SB 35 was a bill that was originally passed in 2017 that said that if you're a city or a county that has failed to meet those numbers that are mandated by, you haven't approved or developed enough units to meet the numbers mandated by the state, then if a qualifying project is proposed, then you must streamline that project, and it can't be subject to certain requirements that you otherwise would impose. And the streamlining approval is similar to the last one that I mentioned, which is 60 days if the project has fewer than 150 units, and 90 days if 150 units or more. So this bill, SB,
More things. So HCD, the Department of Housing and Community Development at the state level, publishes a list, I think it might be annually, that identifies which cities and counties are subject to this law. It basically allows a streamlined, a faster approval process than you normally would have to go through, and it's ministerial, and there's no discretionary approvals. So a lot of cities are frustrated that they have to approve projects that they otherwise would not want to be approving. It applies to anywhere that allows housing. There are some specific requirements about which sites are eligible for this process, in addition to having to be in the city or county that's been identified. I don't know off the top of my head all the sites. I know now as you have spent time with it, so you might know a little better, but it's certain things like you have to be in like an urban area, you have to have like 75% of the property surrounded by urban, no, maybe not, maybe I'm making that up.
No, that's right, yeah. Urban uses.
There's a long list of categories that have to be met to qualify. And then there's also a newer process, it's not new though, it's been around for a couple years now, where you have to submit what's called a preliminary application to notify the jurisdiction that you're intending on pursuing this process. And that triggers to the city or county to then go notify the tribes in the area, and they have, I think, 30 days to let you know if there are any concerns with tribal resources on the property. And then once that whole process is done, the application for this can actually be submitted. And there are some affordability requirements. It depends on if the jurisdiction is meeting their moderate income needs allocation, their lower income needs allocation. In most places, the requirement is that 50% of the units be at a low income level, which is typically 80% of a I think that's a good background.
much more thorough than what I was providing, but
So Nazanin is now going to tell us what's changing next year with this law.
yes. So for one, this bill extends SB 35 to 2036. So they're saying it's working. So
Do you remember when it was originally set to sunset? Was it like
2026. Yeah. It also extends SB 35 into coastal zones. So as Gabrielle mentioned, there are a number of requirements related to where the parcel is located, and several of these are environmental requirements. Can't be in a floodplain, can't be in the coastal zone, can't be in a very high fire severity zone, subject to some exemptions. There's about say 9 environmental exemptions. But basically SB 35 says away with the coastal zone exemption. We're applying this in the coastal zone now. And for those who don't know, the coastal zone is, the stretch of land from the top of California all the way down and it's under the jurisdiction of the California Coastal Commission. So there are additional approval requirements for projects that are proposed in the coastal zone. You have to get a coastal development permit. And so previously, SB 35, these types of projects could not be proposed in that area, but now they can. This doesn't take away the authority of the Coastal Commission related to those. It just sort of curtails it and says you have to do it on this faster timeline that SB 35 imposes. Perhaps most significantly, SB 423 extends SB 35 to any city or county that has not adopted a housing element that HCD has found to be in substantial compliance with housing element law. So now it's not just if you haven't met your RENA numbers, but also if you haven't adopted a housing element that HCD has certified, then an SB 35 project can be proposed in your jurisdiction. It also reduces the affordable percentage to 10% if the housing element has not been found to be in compliance, so rather than the 50%, it's 10%. And for rental projects, so previously there was a requirement for rental project, for both rental and for sale projects, that you have 50, sorry, check this so I'm saying it correctly. So yeah, previously it was that you dedicate a minimum of 10% to households at or below 50% of AMI, and now with rental projects, it's at least 10% of the total units at or below 50% of AMI. So it lowered the affordability level. It's a much deeper level of affordability that must be imposed. And then, yeah, it also removes the authority of local jurisdictions to do public oversight, and instead says that it adds a new process in addition to all the things that Gabrielle mentioned that have to happen before an application. It adds a new process that has to happen before the application, where if it's in certain low or moderate resource areas or areas of high poverty and segregation, then the jurisdiction has to have a public meeting where they take public comment about the project, and then only after that meeting has happened and those comments have been taken, can the project be proposed officially.
All right, so next is the Affordable Housing on Faith and Higher Education Lands Act. So this similarly provides a ministerial process, a use by right is what they call it here. And it needs to be requested by the project applicant, and it applies to properties that are owned by independent institutions of higher education and religious institutions. Independent institutions of higher education are non-public higher education institutions that provide undergraduate degrees, graduate degrees, or both. And then religious institution is an institution that's owned, controlled, operated, maintained by a church, religious denomination, or religious organization that is lawfully operating as a nonprofit under the Corporations Code. Use by right under this bill means a development project does not require a conditional use permit, land unit development permit, or any other discretionary local government review. And this also implies that it is not a project for the purposes of CEQA, the California Environmental Quality Act. So to utilize this process, there are 15 specific criteria that need to be met, which I'm not going to go over. That is a lot. But some of the key ones are that the site needs to be meet the eligibility requirements for SB 35, which we just went over. And there are some other specific location requirements if the site is near an industrial use. The project needs to be entirely affordable. So 80% of the units need to be affordable to lower income households and 20% to moderate income households. And then there's an exception to have a manager's unit on the site. The property needs to have been owned on or before January 1st, 2024 by the religious or higher education institution. And then there are some replacement housing requirements that need to be met if housing is being demolished. I think we're going to go into that in a little bit later, so I won't go over this right now. The density that is allowed on these sites. So if the site is an important thing for a lot of residential developers. If a site is located in a zone that allows residential use, then the density needs to allow what is considered appropriate to accommodate lower income units. What that means is, in housing element law, the state has said that certain density is automatically considered to accommodate lower income housing. So what that is for an incorporated city in a non-metropolitan county, or for a non-metropolitan county that has a micropolitan area that is 15 dwelling units per acre, for an unincorporated area that is not a metropolitan county, it's 10 dwelling units per acre. For a suburban jurisdiction, it's 20 dwelling units per acre, and for a jurisdiction in a metropolitan county, it's 30 dwelling units per acre. So regardless of what the residential zone allows, if you're developing one of these projects, you get to have one of those densities. And then for the height, they allow 1 story above the maximum height that is otherwise applicable to the parcel. If the project is proposed on a location that is not a residential zoned location, the density is 40 dwelling units per acre. And then similarly, it allows for a 1 story above the maximum height that would otherwise be allowed. There's also some parking requirements. It's 1 parking space per unit unless it's within a half mile of public transit, which then does not require parking. And then there's also some labor requirements that go with this law. So if you wanted to utilize this law, the project would either have to be considered a public work project, which in most cases it will not be, or the construction workers need to be paid prevailing wage. And I don't know how many of you have worked with prevailing wage, but it does increase the cost of construction by quite a lot. So I honestly don't know how often this is going to be used, but it's now on the books, and it is an option for religious institutions and independent institutions of higher education. Okay, so density bonus.
Yeah.
We'll talk a little bit for that.
As Gabrielle mentioned, density tends to be an important factor for a lot of residential developers, and can sort of make or break projects depending on density. So density bonus law, basically at a very high level, it provides, it allows additional density to be added if a developer is providing a certain amount of affordable housing. So you have your underlying zoning, which tells you what your base density could be. So for instance, on a 1 acre parcel, it's 20 dwelling units per acre. That would be your base density in that case. And what density bonus law does, it says if you provide X amount of lower income units, very low income units, then you get X amount of additional density. So you just take whatever and I'm not going to go through each of the density bonuses because there's charts and charts in the law that tell.
And that in itself is an hour-long plus.
Yes. But basically it allows you to build additional units where as long as you're providing some amount of affordable housing. What density bonus law also does is that it provides for something called concessions or incentives. So basically says if you are providing X amount of affordable housing, you also get to ask the jurisdiction to not apply certain development standards. And so that ranges from, the lowest amount of additional or affordable housing that you're providing, you get one incentive up to the top, which is 4 incentives. And those are basically just, if I'm trying to think of an example of something, so, there's a open space requirement on the property, and you want to provide less open space, then you'd ask for an incentive in that, or one of your concessions to be the waiver of that, now it's the word waiver, alleviation, yes, from that requirement. Because density bonus law also provides for waivers, which are waivers of development standards that would otherwise physically preclude you from building your project at the density proposed.
And with the concession granted.
And with the concession
Yeah.
granted. And the last thing that density bonus law does is it provides certain parking ratios, so it lowers the required parking amounts as well, the number of required parking spaces that a project must provide. And all of these are basically on a as requested basis, so it's possible that a developer could propose a density bonus project, but actually not get additional density and just seek the incentives or the waivers or the parking ratios. You don't have to build the additional units. As long as you're providing the affordable housing, then you are entitled to any piece of what density bonus law provides.
I don't remember if Naz mentioned this, but you can have unlimited waivers. So in effect, if you're providing affordable housing in your project, you can get out of a lot of a city or county's development standards. So it's a very popular tool for development. And then one thing, we're not going to spend any time talking about this, but I did just quickly want to point out, a lot of jurisdictions have inclusionary housing requirements, which require a certain percentage of housing developments to be affordable. If that is the case and affordable housing is being provided under that requirement, that counts towards density bonus. So since most jurisdictions do require it, pretty much every residential project is eligible for, at a minimum, waivers, and depending on how much potentially incentives, and then also increased density, which not everyone wants to take advantage of.
So AB 1287, which is the main density bonus bill from this session, does a few things. The first is that it requires local jurisdictions to grant additional density where the housing development would restrict more than 50% of the total units to moderate income, lower income, or very low income. The applicant agrees to include additional rental or for sale units affordable to very low income households or moderate income households. And the housing development does either of the following. It conforms to a section of density bonus law 65915B1A and provides 24% of the total units to lower income households, conforms to that same section and provides 15% of the total units to very low income households, or conforms to 65915B1D and provides 44% of the total units to moderate income households. So basically it just increases the density bonus that a jurisdiction must provide where additional low, very low, and moderate income units are being provided by the developer. It also slightly changes the definition of maximum allowable residential density. So this is the base density that I was talking about that you start off with and then you apply the density bonus to. And basically revises it to say it's the greatest number of units allowed under the zoning ordinance, specific plan, or land use element of the general plan applicable to the project. And then lastly, it increases the number of incentives, increases the number of incentives from 4 to 5 for 100% affordable housing projects. So SB 713 modifies the definition of development standard so previously it was a site or construction condition that applies to residential development pursuant to any ordinance, general plan element, specific plan, charter, or other local condition, law, policy, resolution, or regulation that is adopted by the local government. It now adds the clause, or that is enacted by the local government's electorate, exercising its local initiative or referendum power, whether that power is derived from the California Constitution, statute, charter, etc. And so basically what that means is that it's not only the development standards that are adopted by the city council or the county board of supervisors, town council, it is also those that are imposed by the electorate via a voter adopted initiative, essentially. So if they adopt some development standard or limitations via voter initiative, and that also is a development standard that can either be waived or that can be that you use an incentive or concession to deviate from.
Just a personal comment, land use planning by initiative is a terrible idea.
Question?
Yes.
Waivers. They're in particular on certain things that a county or city may want the developer to do, such as an art requirement, art pieces, open land. Well, I guess my question is, obviously there's probably more than 5 they can choose from. Who gets to decide which ones they can pick from?
So the developer would propose what they want, and then the city basically has to grant it. I think in the bill it also, previously a city could require some documentation showing, explaining why it would be an economic burden to provide this, and I think that requirement is taken out of the law going forward. But yeah, the developer is going to propose what they want, and then the city has to, I forget the standard, but there is a burden of proof if the city wants to deny it. And they also need to show that there's potential health and safety impact that can't be mitigated to deny it. So it's very hard to deny this request. But yeah, it's proposed by the developer.
Yeah, and to reiterate the difference between a waiver and a concession or an incentive. A waiver is you would waive a development standard that is a financial burden, so that would financially prevent you from building the project, whereas for incentives or concessions, those are development standards that would physically prevent. Oh, sorry.
In the end, it ends up being very similar. You're waiving development standards, you're deviating from what's required. It's just whether it's based on economics, the financial feasibility of the project versus the physical feasibility of the project. And so we're talking like setbacks, open space requirements, building height requirements, those sorts of things. You cannot get a waiver or an incentive from a state building code standard. So. Okay, are we moving on?
Yeah.
Okay. HOA assessments.
All right. So AB 572. It amends the Davis-Sterling Common Interest Development Act to restrict the amount by which an association, a homeowners association or cooperative can annually increase the regular assessment on the owner of a deed-restricted affordable housing unit. So as Gabrielle mentioned, a lot of cities and counties have inclusionary housing requirements, which now require the developers of condominium buildings or other common interest developments to include a certain percentage of those units basically at an affordable housing price that is affordable to lower income households or whatever, income they require that to be restricted to. And basically this law says that you cannot increase the regular assessments as an association that has inclusionary housing units, you cannot increase the regular assessment on the owner of one of those affordable housing units by 5% plus the percentage change in the consumer price index, or 10%, whichever is lower, any over the prior year's assessments. And this is actually pretty in line with what we'll talk about later, which is the Tenant Protection Act, which restricts rent increases to tenants, many tenants in California. So it's aligned with what is required by that law.
Okay, so there is a new law now that allows a city or county to adopt an ordinance that requires residential development projects to reserve up to 10% of the project unit for artists. Artists are defined as creators of any work of visual, graphic, performing art of any media. And it's up to 10%. There are certain requirements on where the property is located. It needs to be in either a certified state designated cultural district or within a similarly locally designated district. I think the big takeaway with this is the city has to, or the county has to adopt an ordinance to require it. So if you're developing in a community that doesn't have this ordinance, it's not going to apply to a project. Okay, oh god, this is a big one. Streamlined approvals for 10 or fewer units. Was SB9 last year? I think
2 years.
2 years ago. I'm like losing track of years. So a couple years ago, there was this bill called SB9 that amended the Subdivision Map Act to allow certain types of subdivisions to be approved ministerially. So this continues that trend. It adds 3 new sections to the government code for streamlining certain parcels and tentative maps, housing developments, and building permits. So in the Subdivision Map Act, it adds a provision that requires a local agency to ministerially consider, without a discretionary review or hearing, a parcel map or tentative and final map for a housing development project that meets the requirements of the statute. The subdivision must result in 10 or fewer lots, and the proposed development has to contain 10 or fewer residential units, and that has to comply with the other new government code section that deals with the housing portion, and I'll get into that momentarily. So the lot to be subdivided has to meet specific requirements, such as it needs to be in a multifamily zone. It cannot be larger than 5 acres. It needs to be substantially surrounded by urban uses, which is defined in the statute. It needs to be located in a city that includes an urban area or a county with an urbanized area. There's other requirements. For example, it can't be on prime farmland, wetlands, very high fire severity zones, etc. There's, I think, a fairly long list. The newly created lots cannot be smaller than 600 square feet, and they otherwise need to comply with the Subdivision Map Act. They need to be served by a public water and municipal sewer system, and then they could not have been, the lot you're subdividing cannot have been created with this urban lot split process that went into law a couple of years ago. And then the units must be constructed on fee simple ownership lots, part of a common interest development, part of a housing cooperative, or owned by a community land trust. So the main takeaway is the city has to ministerially approve these proposals. For the housing development portion of this proposal, the floor space of the proposed housing cannot exceed 1,700 square feet. The city's objective standards can be exposed, except that if it would physically preclude the development of the project, then that cannot be imposed. The project can meet the densities that are provided under the housing element law, which is what I discussed a little bit earlier about the 10 dwelling units per acre, 15, 20, 30, depending on the jurisdiction. between the units cannot be required except as in the California Building Code. The city or county cannot require enclosed or covered parking. So there's a whole bunch of requirements that go along with these projects, but takeaway is you get to have ministerial approval. And then when it comes to building permits, this part's a little funky. The building official or city must issue the building permit for the project if requested before a final map is recorded. So to me, that's very weird. But so if they've received a tentative map approval, then they can get a building permit. And then there can be a condition on that building permit that the certificate of occupancy will not be issued until the final map has been recorded. And there needs to be a guarantee at the time of issuance of building permits that sewer requirements, dedications, and public improvements that are necessary must be guaranteed. And the last point is that a building official can choose to deny the building permit if they make written findings that the construction before recordation of the final map would have specific adverse impacts to public health and safety, and that there is no feasible method to mitigate or avoid that impact. I have a tendency of coughing when I'm presenting, so I apologize. Okay, parking. Parking seems to be a big deal for everyone. So we have 3 new parking bills. Only 2 of them are on the slides. AB 894 allows owners of underutilized parking to enter into a shared parking agreement with another party. And that shared parking can count towards the required parking for the development or the use. I don't think this is a new concept. I think there are jurisdictions that are already doing this. However, this is now in state law. In order to be considered an underutilized parking, at least 20% of the parking spaces need to not be occupied. The parking needs to be located on contiguous parcel or not more than 2,000 feet by walking travel to the person who's using the parking. And the shared agreement can be approved or denied by the city or county if it's being used to meet parking requirements. Then there's some other, if an ordinance is adopted that spells out when it will be approved, then these are approved. If there is no ordinance, then notice needs to be provided to property owners within 300 feet. And if a meeting is requested by one of those property owners within 14 days of the notice, within 14 days, then a public hearing needs to be held on the proposed shared parking. I think that's the big takeaway on that one. AB 1308 prohibits local agencies from imposing higher parking minimums as a condition of approval for a remodel, renovation, or addition to a single-family home, as long as the maximum size requirements for the home are not exceeded. And then the third parking bill that's not on the slide because it does not apply to Contra Costa County. However, if any of you are developing in the 10 counties that it does apply to, it requires residential developments with 16 or more units that are issued a certificate of occupancy after January 1st, 2025 to unbundle the parking from the lease of a residential unit. And the counties that it applies to are Alameda, Fresno, Los Angeles, Riverside, Sacramento, San Bernardino, San Joaquin, Santa Clara, Shasta, and Ventura. So that's that on parking. General plan and zoning consistency. So this is a very, I guess this is like the overarching concept in land use planning is that your general plan and your zoning need to be consistent with each other. Of course, that sometimes doesn't always happen, like a zoning amendment might occur or a general plan amendment might occur, and then a change in the other document doesn't happen right away. So this law is intended to address what happens when a zoning ordinance is not consistent with the general plan. And it applies to projects that are not eligible to the Housing Accountability Act. we're not gonna go into the Housing Accountability Act today, but the Housing Accountability Act is a law that makes it more difficult to deny a housing project which has 2 or more residential units that complies with all the objective standards, design, zoning, map standards of a jurisdiction. So this applies to projects that don't fall within that. So, commercial, industrial, I guess single-family homes potentially as well. So what happens if the zoning and the general plan are not consistent is that if a project is submitted that is consistent with the general plan, but not with the zoning, that is inconsistent with the general plan, the local agency has 2 options. They either have to amend the zoning ordinance within 180 days of receiving the application to make it consistent with the general plan, or if that does not happen, then the agency must process the development application and any objective general plan standards that are not, that are inconsistent do not apply. So, yeah, that's that. There is an opportunity to bring an action to enforce compliance within 90 days of the local agency's failure to comply. So, there you have it. Accessory dwelling units. How familiar are all of you with accessory dwelling units? A little bit. Okay, I'm not going to go into all the details. But basically, a city or county has to allow ministerially accessory dwelling units on single-family properties and also multi-family properties if they meet the specified requirements. So we have 3 changes to ADU law. The first one has to do with owner occupancy. The law used to say that for ADUs approved after January 1st, 2025, a local agency could impose an owner occupancy requirement. So basically saying the owner of the property needs to reside in either the primary dwelling unit or the accessory dwelling unit. That has been removed from the law. So a city or county cannot require that the property owner reside in one of the units. This does not change the requirement in junior accessory dwelling units. So junior accessory dwelling units still do have an owner occupancy requirement. The major change, I would say, is that currently the primary dwelling unit and the accessory dwelling unit cannot be sold separately. There is like one very specific limited circumstance that has to do with a certain nonprofit that meets specific qualifications, and I think they can be sold as a tenancy in common. But now, if a city or county wants to allow the separate conveyance of the unit, of the primary unit and the accessory dwelling unit, they can adopt an ordinance that allows that. It has to meet a bunch of requirements, and these units could be sold as condominium units. That's like the major change, I would say. But again, it's only if the city or county wants to do it and they have to adopt an ordinance to allow it. And then the last change to ADU law is that it requires a local agency to create a program to pre-approve ADU plans. And then if someone is using one of those ADU plans, the processing timeline is faster. It already is very fast for cities, and the city even faster, so I think it's going to be a little challenging, but we'll see. And that program starts January 1st, 2025. Okay. How familiar are all of you with the California Environmental Quality Act? This is something I think we run into a lot. It applies to basically every discretionary public action, or every discretionary action taken by a public agency. So if a public agency is involved in anything you're doing, there's a good chance you're going to have to comply with CEQA in some way or other. So this is the list of changes to CEQA this year, or at least the ones that are related to housing. The first one has to do with affordable housing. There's an exemption for that. We have until 3:30, right? Okay. So there's a specific exemption for public agency actions for affordable housing projects. There's a definition of what that means in the statute. I'm not going to go into it, but there needs, it has to be affordable. I think 100% affordable. There needs to be a tax credit allocation regulatory agreement on the property. The site needs to be, have 75% surrounded by urban uses. There needs to be labor standards, so prevailing wage, basically. And then it applies to public agency actions, are for the issuance of entitlements, for lease agreements, conveyances, encumbrances of public land, actions to provide financial assistance, and rezoning or general plan amendments to allow the affordable housing on that location. And then the site also has to meet the requirements of SB 35 that we discussed earlier. That's all I want to talk about for that one. There's a lot of requirements if you want to utilize this exemption, and frankly, you can probably find an easier exemption to use if you're looking for a CEQA exemption. Okay, here's another one. There's a case that came out earlier this year about a project at UC Berkeley, I believe it was. I don't know if you all are familiar with it, but there was a proposal to develop more student housing, and a lawsuit was filed under CEQA and claiming that the EIR did not adequately analyze noise impacts from the population that would reside in the building. And the Court of Appeal agreed with that. As you can imagine, there's a lot of issues with that decision. So the legislature passed a law that said that noise generated by occupants of residential projects are not a significant impact on the environment. And this was an urgency bill, so it's already in effect. So, yeah, that's that. Basically, if you have a bunch of students living in a house, they're going to be noisy, and it's not an environmental impact. Okay, aesthetic impacts. This was already existing in CEQA. It provides that a lead agency is not required to evaluate the aesthetic effects of a project, and the aesthetic effects shall not be considered significant if the project involves refurbishment, conversion, repurposing, or replacement of an existing building that meets specified requirements. This was set to sunset January 1, 2024, and this exemption has been extended to January 1, 2029. The next one, it has to do with notice of determination. So when a local agency files a notice of determination with the applicable county clerk for where the project is located, they now must also file the notice with the state clearinghouse. So kind of a minor change, that just one more thing that people need to remember to do. The Office of Planning and Research has 24 hours to then post it on their website. Okay, motel conversions. This is also existing law. There's an exemption for projects related to the conversion of a structure that has a certificate of occupancy as a motel, hotel, residential hotel, or hostel that is then converted to supportive or transitional housing. This was set to sunset on January 1, 2025, and that has been removed, so it is now, there is no sunset, it just is law now. And then this bill also extends the application for procedures for environmental leadership transit projects. I have to say, I have no idea what that is, but anyway, that's extended as well. And then, okay, we have two more. There is an exemption for financial assistance to residential housing projects. It currently is only available for financing provided by HCD, the Housing and Community Development Department of the state, and also the California Housing Finance Agency. This bill extends that exemption to other local agencies that are providing financial assistance to developments of residential housing for low and moderate income households. And the only requirement is that they would be a responsible agency, not a lead agency. And that also the project needs to have CEQA analysis otherwise. So perhaps not through the county that's giving money, but the city that's issuing the permits. Okay. This last one is actually not a CEQA bill, it's an amendment to the Housing Accountability Act. It is very confusing, but it deals with CEQA, which is why we're talking about it here. So it amends the Housing Accountability Act to expand the definition of what it means to disapprove a housing development project. There is a definition of that in the Housing Accountability Act. And it adds to that definition that certain circumstances when a public agency fails to make a determination under CEQA or they require additional analysis that shouldn't be required before approving CEQA documents, those are now considered reasons that a project would be considered disapproved. And unless you guys want more detail on that, I think I'm just gonna leave it at that. Okay, so next, we're gonna talk about landlord-tenant law.
Are there any questions on the CEQA?
Or the previous stuff that we've talked about, we've gone over a lot.
Any predictions on which laws will be utilized the most for developments or they not?
So these all have an affordability component. So the question is, how much affordable housing developers are providing? I think the ones that require prevailing wage are less likely to be utilized just because of the costs involved. Though SB 35 also has a prevailing wage component and a lot of people are using it. So you never know. But I think the majority of projects I'm seeing with SB 35 are entirely affordable and they would have prevailing wage requirements from some other financing sources. So I guess there's that. If there's not financing that requires prevailing wage, then I don't know how useful it would be just because of the costs involved.
There are programs available too to fund these developments too, right? When buyers they're buying them and building them, but they're borrowing money at very good rates, they're getting grants and lots of other assistance, right?
Right, so for affordable housing projects, there are a lot of funding sources, and they're all layered on top of each other, and it gets rather complicated. They have different requirements. But yeah, there are loans that are at very low interest rates that have a very long repayment time period. Some cities and counties provide grants. I would say that's less often because it does trigger prevailing wage in some instances, and if the project isn't otherwise paying for that, they might not want that requirement.
Is there some sort of auditing after they're built and occupied to make sure they're complying with these density restrictions and realities?
Yes, yeah, so most jurisdictions, as part of the agreement to receive this additional density or the waivers and concessions or loans, they enter into an agreement that's recorded on title to the property that requires the affordability for typically 55 years, but some jurisdictions require it longer if it's their own like inclusionary program or funding. And then there is an annual reporting requirement, so the property developer or manager would have to provide annual reports to the funding sources or the city if it's just a land use restriction, demonstrating that the target population is living in the units. And they do that by having the tenants certify their incomes every year.
Have you heard of any laws surrounding below market rate housing or density bonus housing protecting a seller in a real estate transaction from having to disclose a heads-up buyer down the street, there's a new, the motel's being converted over, or there's increased density at this property down the way, declaring it to be not a material fact that a seller would have to disclose or a change in the neighborhood.
I have not heard of that, no.
Okay. I heard about that for residential care facilities that are part of a neighborhood. I was wondering if the NIMBYs have convinced the legislature to try to protect those projects.
No, and these are, these are all public anyways, if someone could find out.
Yeah.
If it's not disclosed. But no, and I would say the YIMBYs actually have a lot of sway in government right now.
Cool.
So, any other questions before we talk about landlord tenant?
All right. So, we can go to the first, I can do that too, sorry. All right, let's talk about what I consider to be slightly simpler landlord-tenant law. So currently, landlord-tenant law provides that a landlord can charge a tenant up to 2 months of rent and a security deposit for an unfurnished unit and up to 3 months for a furnished unit. This new bill, AB 12, prohibits landlords from demanding more than 1 month of rent plus any amount that they're asking for the actual first month's rent. So basically your security deposit now cannot exceed more than 1 month's rent. So the rent for that unit is $2,000, that your security deposit that you can ask for is only $2,000.
Unless you only have 2 units.
Unless you only have 2. Yeah, there's a
Right.
limit.
Yes.
Natural person too.
And the landlord is a natural person, so meaning not an LLC or.
Trustee,
I'm actually not sure what the definition of natural person is in AB 12. I would have to look it up. And the reason I say that is because it's a little bit.
and there's no difference.
We'll talk about in the amendments to the Tenant Protection Act. You would think that a natural person would just be.
And you, and no restriction on furnished or not furnished, right?
Right, yeah. So just 1 month's rent now. So maximum you can ask for 2 months rent because you would be asking for the first month, the actual first month's rent, and then a security deposit. And that goes into effect in July of 2024, so it does not apply to existing tenancies, yes.
Does it affect when they get last month's rent plus the security deposit, or can you still get last month's rent?
No, you cannot get last month.
Last month's rent is right after.
Yeah.
Anyway.
So. There is an exception in here for terms of tenancy that are less than six months or less. You can't ask for the whole amount in that case, but that's always been, that's existing law, it doesn't change that, so you can ask for 6 months of rent ahead of time for those shorter term tenancies. Okay. Section 8, credit history. So, I think this was also 2 years ago, maybe 3 years ago now, but the legislature passed a bill prohibiting source of income discrimination. And what that basically means is that if you can't discriminate against a tenant because they have a Section 8 voucher or other rental subsidy. So you can't say, I don't, if you have listings on Craigslist that say no Section 8 tenants, you can't do that type of stuff anymore. Can't deny people, basically if you have the same type of tenant and one of them has Section 8, the other one doesn't, you can't treat them any differently. So what this does is it adds an additional restriction on landlords and says that it prohibits the use of a person's credit report as part of the application process for rental housing accommodation, unless the landlord also offers the option of providing a lawful, verifiable alternate evidence of the applicant's ability to pay, including their government benefits. So basically, you can't do a credit check unless you also allow them to say, actually, I have this alternate evidence of my ability to pay the rent each month, which is that I'm receiving Section 8. So I'm going to be able to pay.
Child support or spousal support or anything else, right?
Any questions on that?
Practically, how do you advise your property manager clients who might normally look for a credit check up front before knowing somebody has government benefit payments?
You would just, you would just offer that up front, say, or if you're talking to a prospective tenant, say, hey, we do a credit check, or if you have Section 8, then you can submit that as instead. type.
I think there's a couple of other things too that we could
Yeah,
add
they're,
instead.
it's not just the section 8, but
Okay.
no, it's like doing the whole thing in the middle again. Did you restart it? Like closed out already?
I don't think we have too many more slides. Maybe we could read our slides too.
Yeah.
One, two, three more.
Okay. While Nazanin's getting ready, I will read the slide and then she will talk about it.
No, I mean, I can do it. Okay, so in 2019, the state legislature passed the Tenant Protection Act, which added rent caps and just cause for eviction protections for many tenants across the state. And the rent caps are 5% plus CPI or 10%, whichever is lower. And the just cause for eviction protections apply to any tenancy where a tenant has resided in the unit for at least 12 months. After those 12 months, you have to provide one of the just causes before terminating their tenancy. You cannot do a no cause termination of the tenancy. And the statute provides for, can't remember now, it's 12, 13 just causes. Some of them are at-fault just causes, which is things like not paying your rent, or committing criminal activity, committing a nuisance, breaking release, subletting, things like that. The others are no-fault just causes, and two of those no-fault just causes include owner move-in, which is where either the owner or one of the qualifying relatives of the owner, so it can't be like your third cousin, twice removed. I don't even know what twice removed means, by the way. You know, it has to be like your parent, grandparent, child, spouse, domestic partner, wants to move in, then you can evict a tenant. And the second one is a substantial remodel. There was a recognition after the passing of the Tenant Protection Act that some of these no-fault just causes were being used as loopholes. So people were saying, oh, I'm going to move into this unit, I'm doing an owner move-in, and then never moving in. So this bill, SB 567, makes some amendments to two of those just causes, which is one, the owner move-in one. There are now requirements and limitations as to who can use an owner move-in, and this is where I was talking about the natural person thing. It's the definition of a natural person is very convoluted in there, but essentially limits. Let me look at it exactly so I can provide the proper language. So it says that an owner can do an owner move-in, and an owner is a natural person that has at least 25% recorded ownership interest in the property, or an owner who is a natural person who has any recorded ownership interest in the property if 100% of the recorded ownership is divided among owners who are related to each other as siblings, spouse, domestic partner, child, parent, grandparent, or grandchild. Or an owner who is a natural person whose recorded interest in the property is owned through a limited liability company or partnership. And the natural person includes a natural person who is a settlor or beneficiary of the family trust. If the property is owned by a limited liability company or partnership, a natural person with a 25% ownership interest in the property. So, like I said, that definition is very complicated, but basically limits who can you do an owner move-in, and then also there are certain requirements now related to you have to move in within 90 days after the tenant has vacated and have to occupy for 12 months continuously. thereafter, and if you don't, then you have to offer the unit to the tenant who vacated it at the same rent and the same lease terms that were in effect at the time that the tenant vacated it, and also reimburse the tenant for any moving expenses.
Don't you, you have to reserve this right too in your lease, don't you? You have to reserve the right to own or move in
Yes,
your
you
lease.
do. Yep.
Then you do them 30-day notice to change.
Let me make sure I covered. Oh, and if you die before you've been able to
You have to give notice.
move in after 90 days after the tenant vacates, or before you're able to occupy for 12 months as your primary residence, then this requirement to reoffer does not apply. I assume because you are not alive. And then, as I mentioned, SB 567 also amends or adds additional requirements for substantial remodel evictions, and provides that a substantial remodel means that the remodel cannot happen in a safe manner with the tenant living in the unit, and requires the tenant to vacate for at least 30 consecutive days, and includes either the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit from a governmental agency, or the abatement of hazardous materials in accordance with applicable law. Let's see.
You can change that. I'm just going for so you.
And then there's certain requirements related to the notice that you have to provide for these substantial remodels, and you have to provide a copy of the permits if it's a type that requires permits.
And you gotta pay a relocation fee. Okay?
Sorry?
And you gotta pay the tenant a relocation fee.
What kind of business?
Well, yeah, that's always been a requirement. It's still the 1 month of their rent. You either waive it or it's a check in the amount of 1 month.
But there's also city ordinances that change that, like Concord is.
Right.
3 months rent or
Yes.
5,000, what's left?
Yeah. I have
Yes. Yeah, so there might be locally applicable relocation now for these types of evictions. And then it also adds the ability of the tenant to bring a civil action against a property owner who demands or accepts payment of rent in excess of the maximum amount allowed under the Tenant Protection Act. Is this working now? No.
Were there any changes to the
Okay.
removal from the rental market exemption? Any changes to that?
Sorry.
One of the no fault was that justifiable reasons is removal from the rental market. There's been a lot of ambivalence on what that means. Was that clarified at all in these new statutes?
No, I think that's meant for Ellis Act evictions, so usually that's gonna be governed by like the local, if the city or the county has adopted Ellis Act regulations for removal from the rental market, but no, there was not any changes made to that requirement under the Tenant Protection Act.
I think the question is, if you're just gonna sell it, is that removing from a rental market? Because lots of landlords just wanna get out of being landlords and they wanna
Right.
get the tenants out for better value. So
You mean for a single family home?
the single family homes are exempt anyway, right?
Some of them from the Tenant Protection Act, if they're owned by a corporation or an LLC in which a corporation is one of the members.
For the most part, it's mom and pop.
But a mom and pop, one is exempt, yes.
So if you were to do a just cause where you're gonna take the property out of the market but not sell it, and you need to, I assume, go through the same step, offer it back to the tenant and go back in, is that, you didn't end up following through with selling the property?
Again, that is partly governed by local Ellis regulations, yeah. Okay. So, Costa-Hawkins is a state law that did a number of things related to rent control and placing limitations on rent control by local jurisdictions, including providing or getting rid of what is called vacancy control, which was basically when a unit turned over from one tenant to the next. A lot of jurisdictions with rent control, we're saying you have to keep the same rental amount from one tenant to the next. You could not reset the rental amount for the new tenant. Costa Hawkins altered that and said landlords have an unequivocal right to reset the rent when the unit turns over from one tenant to the next. So now in any rent controlled jurisdiction, if one tenant departs, the landlord can reset the rent for that unit to whatever they want, to the market rate for the next tenant. This bill, AB 1620, provides a small exemption to that unequivocal right of the landlord to reset the rent, and basically provides that if a tenant who has a permanent physical disability related to mobility has to move to a different unit on the property that is accessible to them, so basically where you have to provide reasonable modification or accommodation, then that their tenancy in that new unit has to be offered at the same rent and under the same lease terms. Which kind of makes sense, right? If someone has to.
But what if there's the only one available is a 3-bedroom when the disabled tenant is occupying a 2-bedroom?
Yeah, so it says available comparable or smaller unit. So if it's not comparable, typically means same number of bedrooms and bathrooms, so.
But if the new one's bigger, we could talk about a rent increase.
Yes, yeah. I think there's an argument there that you could change the rent if it's bigger unit. Okay. Next. Alright, yes. Okay, so this goes to a bill called the Housing Crisis Act, or SB 330. That was that 2019 or 2020?
Yeah, it was adopted in 2019, went into effect in 2020.
Okay. So basically, what this sought to address is that a lot of developers were buying up rent-controlled units or other deed-restricted units and then demolishing them and building fewer units than previously were on that site. So they would buy a 20-unit building and then maybe demolish those units and build like 14 townhomes or row homes on that. So this bill, when SB 330 in its original form, provided that if certain protected units are demolished, one, they need to be replaced 1 for 1, so you cannot, demolish 20 units and only build 15, you have to build at least 20. And also provided that the tenants of those units with right of first refusal in the new development, as well as relocation assistance of up to 42 months rent differential. So what AB 1218 does is provides that, so previously it only applied to projects that were demolishing residential and building residential. It's now expanded it to any project that is demolishing residential, even if it will build commercial or other type of units or other type of project, and provides that in order for the city or county to approve that type of project, the developer of the commercial, retail, whatever type of project it is, has to provide replacement housing. The replacement housing does not have to be on the same site. It can be elsewhere within the jurisdiction, and you can contract with a different entity, so an affordable housing developer or residential developer, if you're a commercial developer, to provide those units. So basically expands it. And then the applicability, and then that expands the right of first refusal for lower income tenants and the required replacement units, even if the new development is not residential. And provides that replacement housing has to be developed either prior to or concurrent with the development project. So you can't demolish, build your commercial, and then 10 years later build the replacement residential units. Those residential units has to be built at the same time or before the commercial project or other type of project.
One of the reasons for that is in there were circumstances where, and this has to do with a lot of mixed income projects, where if a jurisdiction is requiring affordable housing, for example, under an inclusionary ordinance, the developer would build the market rate first and then run out of time, run out of money, never actually build the affordable. So there's a lot of requirements that go into the affordable has to be built concurrently with the market rate. Okay, so we're at our last few bills and we have 10 minutes. So we'll get through them. We only have 3 left.
These ones should be relatively quick. Yeah, we can go to the next slide. Okay. So, unlawful restrictive covenants. So I think this was maybe last year, 2 years ago, but the legislature passed a bill saying that if you are the owner of residential property and you're building affordable housing, or you own, or you're owner of an affordable housing development, where there's a restrictive covenant on the site that restricts, among other things, the number of persons or families who can reside on the property, then you can file a restrictive covenant modification. And that requires a approval of the county council. So you would submit it to the county clerk would forward it to the county council, who would look over it, see if it meets the criteria under the bill, and then approve that if it does. And basically that restricted covenant modification would get recorded against the property saying, this restricted covenant before no longer applies because it's actually unlawful. So what this does now, this bill requires the county recorder to actually notify the owner or the submitting party of the county council's determination. That seems like big oversight. They didn't include that in the first version. It also authorizes the owner, after they've received the determination, to notify anyone with an interest in the original restrictive covenant. So you send the notice to them, and if that party is notified and they want to challenge this restrictive covenant modification, they have 35 days to do so. This is not required, it's optional, but it seems like basically it's a way of preventing in the future that person that has a potential interest from coming back and saying, you should have been enforcing this restrictive covenant that has been found to be unlawful by the county council. It also prohibits the owner from recording a modification if the owner is not yet the property's record title owner until close of escrow. So you can't actually record this modification until you are the record title owner. Yeah, and I think I already did the last piece.
What's an example of a restrictive covenant, for instance? Authorized limitations?
Like I said, so one, for instance, that limits the number of households that can, or families that can be on the property. So you can only have two
occupants.
Yeah, 2 occupants, something like that. That is no longer considered lawful or restriction. So that's something that you can remove. Or I think even some of them said like you can't have affordable housing on this site. So that's one that you would want to remove, especially if you're an affordable housing developer. Go to the Great. So during the last legislative session, the legislature adopted a bill that shortened the amount of time that local agencies can take to process post-entitlement phase permits. This basically just brings, and a lot of times that required coordination between the city or county government and like the special districts, and the special districts were like not providing responses within the timeframes for these post-entitlement phase permits to be issued. So this basically requires that special districts that receive an application for a housing development project for services or for a permit have to provide written notice to the applicant of the next steps in the review process, within 30 business days of receipt of the application for housing development with 25 or fewer units, and 60 business days if 26 or more units. So basically requires those special districts to process these applications more quickly and more in line with what the local agencies have to do.
What's the consequence for not doing it?
That's a good question. Probably so.
Happens all the time.
Yeah, some of these
Yeah.
requirements that the state imposes on local agencies don't always have consequences. We were just talking about this yesterday, how there's a 5 hearing limit for residential project developments, and we're like, well, what happens if they exceed the 5 hearings? I guess someone could
They
sue,
have the 6th.
right? Yeah, exactly. Exactly. The consequence is you're now, at risk for a lawsuit, but if no one sues you, you just have your 6th hearing. So,
And I mean, these process timelines are so fast that, is it even worth,
What's
is it
the-
more quick, is it more,
What's this thing in the news about the builder's remedy? What's that about? You guys, the cities aren't doing,
do we know about it? Yes,
Yes.
we know about it.
what about it?
You've written a memo on this, right? I'll let you talk about it.
okay, so this goes back to the Housing Accountability Act, which is a topic we were trying to avoid delving into too far today, but I guess I can give a slight overview. So basically the Housing Accountability Act limits the circumstances under which a housing development project that's consistent with zoning and general plan standards can be denied. And basically says, hey, city or county, if you haven't met all of these requirements, you can't deny a project that substantially complies with or that meets all of the objective standards. So the builder's remedy focuses on one section of that, which says that you have to have a substantially compliant housing element in order to be able to deny these types of projects. So it's one of the 4 or 5.
Yeah, and really quickly, the project has to have 20% affordable units.
Okay.
Yes. So basically, if you don't have a substantially compliant housing element, you can't deny a project that is not consistent with your objective standards. So a lot of cities and counties have not met their deadlines for submitting their 6 cycle housing elements. Or if they have met the deadlines, there's arguments to be made, or the different developers are making the arguments that their housing element does not substantially comply with housing element law because HCD has not certified their housing elements yet.
Right.
So they submit what's called a builder's remedy project, which is basically like, we're submitting whatever we want, and because you don't have a substantially compliant housing element, you can't deny it, even though our project doesn't conform to X, Y, and Z pieces of your objective standards.
So that should be fixed by statute at some point.
I don't think it will.
Yeah, I think it's too controversial to be fixed by statute. It's going to be litigation as to whether these housing elements are actually substantially compliant with housing element law or not. So
If they're certified, then is it immune or?
no, there's a rebuttable presumption. So if you have a certification from HCD that there's a rebuttable presumption that your housing element substantially complies with housing element law, but someone could still challenge it. There was a recent case, Martinez v. City of Clovis, where the City of Clovis did have an HCD certified housing element, and it was challenged, and the court said, actually, we don't think that this substantially complies with housing element law. We think HCD was wrong. But there is the reverse is not true. So just because you don't have a certification from HCD doesn't mean that your housing element, there's no presumption that your housing element does not substantially comply.
Where do they go to get this determination that they can do this builder's remedy project?
You just submit an application.
Yeah, they just submit an application to the city or county and they say, you need to process it.
Community development department.
And right, and then if they don't, they refuse to process
sue
it,
them.
you just end up in litigation, so.
Yeah.
They should try to get a mandate.
Yeah, what they're doing is, so part of what they're doing is, so the Housing Crisis Act, one of the things that it added was this preliminary application requirement, right? That was
Yeah, that's it.
thing. And if you submit a preliminary application, it basically says that it freezes the development standards that are applicable to your project. So a lot of these projects are not submitting like full applications yet. They're submitting these preliminary applications while the,
So they can't then pass a new one that is substantial.
exactly, that's the argument. It hasn't, I don't know that it's actually been determined by a court that's the proper interpretation, but that's HCD's interpretation, that if you file a preliminary application while they don't have a substantially compliant housing element, then it freezes that.
Are there any published decisions on this, specifically on this builder's remedy, that like commands the city to accept a particular project and or says it's hereby, you know, ruling by the court that it's accepted?
No, I don't think
Project that hasn't happened.
Yeah, no.
Still waiting on one of those.
Yeah, there might be some superior court
Right.
actions, but I don't think,
Yeah, but even the Beverly Hills case is like about whether the housing element itself is substantially compliant. There's not a builder's remedy project. And in fact, I mean, what's happening right now is that there are a couple of groups, interest groups around the state that are suing these jurisdictions, but there's an argument that they don't have standing.
Right. They're not builders.
Right. Yeah.
okay. So we have, well, we're at time. So we have one last bill, which I don't need to go into, I will briefly. The Surplus Land Act is a body of law that applies to public agencies and their disposition of property. So if you are not working for a public agency, you probably have not run into this unless you represent a buyer trying to purchase public agency-owned property. And there's a whole bunch of requirements that the public agency has to go to in order to sell or lease their property, which we're not going to go into, but the concept is the state wants affordable housing, so there are requirements that the land be offered to affordable housing developers first. The changes that this bill makes is to what is not considered surplus land. There's a list of what that is. If it's not surplus, you don't have to follow this process, you can just sell it. And then there's also some clarification as to whether a lease agreement is considered disposition of property. And under Surplus Land Act, if the lease is less than 15 years, it doesn't have to go through this process. Or if there will be no demolition of buildings and you're renting the buildings, you don't have to go through this process. So that's the very nutshell version. So those are the main laws, the big laws that have come out this year that go into effect next year. Thanks for sticking it out with us a lot. So if you have any other questions, I think Naz and I can stick around for a little bit. You can always feel free to reach out later.
Thank you.
Thank you.